Hi and Assalamualaikum. My name is Nur Azmina binti Nur Azlan. My matric number is S64338. Today I would like to present about the step that can be recommended to overhaul the safety program in the company. Okay, the first is demonstrate company commitment to workplace safety. This step mostly concern management. At first, they must reflect this value in word and action. This doesn't just mean verbal encouragement employee to follow proper safety procedure, but also conducting a true investigation of each and every workplace accident. Okay, the second, assess workplace risk and hazard. We need to get a proper assessment of everyday hazards specific to our workplace. In addition to receiving a professional assessment, management should also release a company-wide survey to give employees the opportunity to express risk concern. Okay, the third is train employee. Um, we must give a provide writing instruction and safe word procedures so they can check for themselves if they are unsure of a task or have forgotten part of their training. The fourth is reporting accident. Reporting accident and ill health at work is a legal requirement. The information enable us to identify where and how risks arise and enable us to investigate serious accident. And lastly, about the implement and evaluate. We must to make sure to investigate all workplace accident, no matter how minor they may be. May often than not, these incidents are entirely preventable, and it's important to determine the cause in order to come to a safer solution in the future. Okay, that's all for me. Thank you.
Assalamualaikum. My name is Siti Norziana binti Rosbi. My matric number S64357. I will present about solution that human resource manager can do in situation involving STEPN. There are three solutions that HRM can do. First is counseling, second is written warning, and third is conduct a domestic inquiry. First is counseling. Counseling is interpersonal in nature and a technique that used by human resource manager to understand and listen to the problem of their subordinate. In this case, Stephen has been suspect of helping his father-in-law to compete with Zomato company. By providing counseling to Stephen, HRM can find out about his father-in-law business and how his business can compete with the business where Stephen works. Second solution that HRM can do is give writing warning, also known as writing note. Writing warning given to employees who commit minor mistake or some major one, such as misconduct. In this case, Sham as HRM need to issue a writing warning to Stephen in case his behavior was deemed to be at fault. For example, Stephen has worked with Syarikat Zomato for 9 years, which allow him to be given 8 weeks of service termination notice as mentioned in Employment Act 1955. The last solution that HRM can do is conduct a domestic inquiry. Domestic inquiry is internal investigation process where the employee need to determine whether a employee has committed misconduct or has been found to have committed misconduct. In Stephen's case, Sham, as a HRM, need to carry out a domestic inquiry for Stephen by obtaining a letter from the employer containing specific allegations such as misconduct, date, time, place, and a rule that have been violated by the Stephen.
Hi, Assalamualaikum. My name is Salwa Soleha Fitri binti Ahmad Tarmizi. My matric number is S64264. Today I will present about question 3, which is the possible consequences to the company for the termination of Stephen's service as described. In this case, Stephen can file a complaint with the Director General of Industrial Relations within 16 days of termination of his employment. The IR department would then arrange for a conciliation between the employer and employee to try and reach a solution. An IR officer will act as a mediator at the meeting. If organization can reach a settlement, an agreement will be drawn up setting out the terms of the agreement and the matter will be considered resolved. It is important to note that no legal representation is allowed at this meeting. Stephen must speak for him or herself or may be represented by an officer of a trade union. If an agreement cannot be reached, the matter will be referred to the Minister of Human Resources. The Minister has the discretion to decide whether or not to refer the case to the industry court. This will usually be done when the Minister is of the opinion that his claim involves a serious issue in law or fact that should be resolved by the industry court. Once an Stephen case is referred to the industry court, the court will determine if the dismissal was just for cause and excuse. If the court finds that the dismissal was without just cause and excuse, it can award the following. Firstly, reinstatement. In practice, reinstatement is not granted often unless the parties agree to reinstatement. Secondly, back wages. Back wages are rewarded to cover the period from the date of dismissal to the date of the award to a maximum of 24 months. If the employee found new employment in that time, it will be taken into account when calculating back payment. Lastly, compensation. In lieu of reinstatement and back wages, Malaysian labour law termination compensation is typically awarded based on the month's salary for every year of service. This could be significant to the employer. Unfairly dismissing a senior, highly paid employee with many years of service could cost the employer hundreds of thousands of ringgit. Stephen is also entitled to file a civil claim for damage against the employer. That's all from me. Thank you.
Hi, Assalamualaikum warahmatullahi wabarakatuh. My name is Fatih Farsha binti Wak Faizal. ID number is S4433 and I will explain about article for question 1 and question 2. In question 1, there has two article. First, I will explain about article 1. A method is currently being developed and is being partly financed by the government of the UK and the Netherlands. This study examines the system theoretical underpins, its simple quantitative and qualitative outputs, present an example application, and identify key area for further development. Example, Nathan had conducted a preliminary investigation into the accident and had reported the incident to the Department of Occupational Safety and Health, DOS. He know that will send out an officer to investigate. He wanted to be ready for any question they might. He also realized that in the last 12 months, the company had neglected the safety and its workers in the interest of ensuring they achieve the production target set for them. I will explain about Article 2. We divided into 4 categories utilizing factor analysis, worker participation, safety preventive and control system, safety agreement and management commitment. 3 case studies were also done to examine the impact of the success variable on construction safety performance. Example, Nathan had prepared a list of the issues that could have led to the accident. They include the worker concerned had been working maximum overtime for the last 2 months and had volunteered for the night shift because he earned a higher rate of pay when he worked at night. The worker had only been with the company for 3 months and so far had not attended any safety training. So next, I will explain about article question 2. Article for question 2 is inclined to forgive other their trespasses is an individualistic society or in the more cutthroat business environment. One is more inclined to embrace the negative emotion of resentment, rage, retribution or retaliation than the virtue of forgiveness while facing interpersonal circumstances involving serious conflict or minor disagreement. Example, Stephen Chong to be dismissed the inefficient performance. Exclaim him to the Human Resources Department. I can't believe it. Stephen been with us more than 9 years, have been promoted twice. He the section leader on almost all of our important production line. Why should he be dismissed, and why I'm not being informed earlier about this decision? So that's all from me. Thank you.
Hi, my name is Muhammad Hazir bin Mazlan. I will present about article for question 3. Okay, let's go for article 1. For article 1. Related to the article, once an employer has taken the decision to terminate employment, the employee has the right to dispute this decision before a court of law, whereby judge will be responsible for ruling on this same. Ruling on termination of employment are regulated in Article 55 and 56 of the Statute for Workers and in Article 108 to 110 of Law 36 2011 of the Social Jurisdiction. Termination of employment without cause or void. At the same time, there are three types of dismissal: discipline, objective, and collective. Discipline termination, Art 54 of ET, is based on a serious and deliberate breach committed by the employee. On the other hand, objective dismissal, Art 52 of the ET, is determined by reasons which are objective as opposed to subjective. This last being characteristic of disciplinary termination and may include breaches of the provision which are neither malicious nor culpable but which are still to the detriment of the employer. Collective dismissal, Art 51 ET, constitute a mechanism for restructuring companies for reasons which are economic, technical, organizational, or related to the production. Next is Article 2 for question 3. According to the article, the relevant legislation covering unfair dismissal is the Industrial Relations Act of 1967, amended 1989. When an employee considered that he or she had been dismissed without just cause of excuse by the employer, they could file a representation under Section 20 of the Industrial Relations Act 1967 at the nearest Industrial Relations Department. This department has the duty of reconciling any differences between the employer and employee with the aim to arrive at a settlement between the parties such that the matter ends at this stage without the need to proceed further.